In March 2020, Manuel Ellis died while he was handcuffed in police custody. 3 officers involved in the incident are on trial. Matthew Collins and Christopher Burbank are charged with second-degree murder and first-degree manslaughter. Timothy Rankin is charged with first-degree manslaughter. Thank you for joining us. I'm Christine Pay. For the duration of the trial, King 5 will recap the biggest developments in the courtroom, and we will discuss what this all means. Today, we sit down with retired Pierce County Superior Court Judge Brian Tollefson, also attorney Mark Lindquist, who served as a Pierce County prosecuting attorney for nearly a decade, and Seattle University School of Law adjunct professor Mo Hamoudi, who also has experience practicing criminal defense law. But first, we're going to go to King 5's Drew Mickelson, who has a recap of the week.
Christine, jurors heard from several experts this week, but the testimony that likely will stick with them is what they heard from Seth Cowden and Ayanna Mang. Those are 2 eyewitnesses, 2 people who were there the night Ellis died. Mang lives at the Tacoma intersection where he died, 96th and Ainsworth. It was her doorbell camera that captured some of that encounter between Tacoma police and Manuel Ellis. She says from her bedroom window, she could see police kick and hit Ellis while he was on the pavement. Seth Cowden was delivering pizzas in that part of Tacoma that night, and he drove up to that intersection and started recording on his phone when he saw the incident. Both witnesses told jurors Ellis did not appear to fight with the officers.
First word that comes to mind would be just panic. I know that he was the one that I could hear scream the most. I could tell the difference between the officer and Manuel Ellis screaming just because his was out of fear and was more sporadic, where the officers were giving orders, basically.
He was saying, "Please, sir, stop." Then the repeated, I can't breathe, I can't breathe."
Defense attorneys pointed out the fact that neither of those witnesses saw how the encounter began, what started the fight, and they also brought up the fact that there's no video showing the beginning of the fight. A couple of other things that came into question: how well could Miss Mang actually see the incident through her bedroom window with police and cars in front of her blocking some of that incident? Also the fact that Mr. Cowden is blind in his right eye, and he testified that he has a hard time with depth perception. Christine?
So as Drew just shared, the jury heard from 2 more eyewitnesses about the confrontation between Tacoma police and Manuel Ellis. Witness Seth Cowden said he did not see Manuel Ellis do anything to provoke the attack from police, and that Ellis seemed scared during the confrontation. Cowden also testified that Ellis did not fight back against police. Keep in mind, he is the 3rd eyewitness to say something to this effect. So let's open it up for discussion now. Mark Lindquist, let's start with you. Do you think that Cowden echoing some of that similar testimony from earlier witnesses that we heard from is going to make any impression on the jury?
Well, it's already established through video that at the point these witnesses are watching, the officers are the ones who are physically active. They're the ones kicking and hitting. At that point, it's pretty clear that Mr. Ellis, well, the civilian from inside our bedroom window said he was resisting and he was turning. He wasn't kicking or fighting. Yeah. So, I don't know that he adds anything, but he affirms some of the prosecution case. And to put this in context, what's going on now is the prosecution's doing a couple things. One, they're trying to deliver on what they promised in opening statement. And every time you deliver on what you promise, you gain a little credibility with the jury. Every time you fail to deliver, you lose a little credibility. The other thing the prosecution is doing, and the defense is doing this too, is they're just trying to bank evidence that they can use in closing argument. In a long trial like this, closing argument starts to become more important than in a short trial, because in a long trial, jurors are more likely to mishear, tune out, or just not remember testimony.
Yes.
So both sides are getting it into the record. I will say this, though, as between those 2 civilian witnesses, it was the second one the woman who seemed more compelling.
Sure.
She had no agenda that I could see.
Yeah. Turning to you, Judge Tollefson, did you have any thoughts on how people regarded or how Seth Cowden was presented before the jury?
Well, you know, from a judicial perspective, realize that the judge isn't trying to weigh the evidence right now. The judge's job is to rule on the admissibility of evidence, rule on the admissibility of testimony, and that's what the judge is doing right now. And the judge will, at the end of the trial, tell the jurors that they're the sole judges of the credibility of the witnesses and the weight that they should give to the testimony of each judge. I mean, excuse me, each witness. And they'll tell that it'll be a very long paragraph that the judge will lay out. Here's what you should consider when you're considering the testimony and the evidence.
Certainly. And turning to the defense's cross-examination, the defense actually brought up a text message exchange between Seth Cowden and James Bible. He is the attorney for the Ellis family. Cowden sent that text after he did an interview with an investigator. So here is how the defense questioned him.
You apologize to Mr. Bible, right?
I don't recall.
If you can look at it, we're on the same page, the very bottom of that.
Yes.
Refresh your recollection.
Yes, I do.
It doesn't indicate that you said to Mr. Bible, I apologize if I said anything disappointing. I tried my best. You see that?
Yes.
And you said that. That's from you, right?
Yes, that's from me.
So Hamoudi, who you're here to kind of give us a little take on how the defense attorneys are approaching this. How do you feel that this moment reflected on Cowden's testimony? I thought it was fascinating that they were really delving into his interactions with James Bible, the family attorney for the Ellis family.
I think that the defense is playing with fire here. What they're trying to do is essentially conflate the civil rights aspect, the civil case, with the criminal case, suggesting that there's some broader credibility issue with all these witnesses because they had communications with Mr. Bible, who's a prominent civil rights attorney in our community. And I do not think that that's an effective approach with these witnesses. You have now 4 separate witnesses who have no relationship with one another, who are consistently saying that the officers are the ones who initiated force. So I do not think that that's an effective strategy to take.
Where do you think they were going with that, though? I mean, were they assuming some sort of conflict of interest, or what were they trying to touch on there?
They're trying to suggest that this individual has a stake in the outcome of this case because he has some bias towards law enforcement generally. And that's fine. He would have probably conceded that he said on cross-examination that I'm not a big fan of authority when he was asked. But that's not going to change the truth. He's not going to get up there and falsify testimony and perjure himself about what he saw. He's admitting that he has biases, and then let the jury consider that. But I think digging too deep into the civil rights aspects of this case with Mr. Bible might end up opening the door to aspects of that might be hurtful to the defense. For example, the statements that were made initially when Mr. Ellis died. And they came out and said that there was no chokehold used. Then that statement was impeached because the video came out. If I'm the prosecutor, I'm thinking, hey, they keep talking about James Bible. Well, I want to start talking about what they were telling people on the front end.
Absolutely, something to look out for as well. But turning now to another witness testimony that we heard from, Ayanna Mang. She witnessed parts of the altercation between Ellis and police from her home. And in court this week, she also testified that she heard Ellis yelling that he could not breathe. Here is that moment from yesterday.
So, again, I'm unclear how many times you heard, which you know was Mr. Ellis saying, I can't breathe. Do you recall?
Four to 5 times.
Okay.
So that was a considerable pause. That was Mang saying that she heard Ellis say that he couldn't breathe from her house. But Judge, would you say that makes a case that the officers heard him as well? That's always been the point of contention from the very beginning.
Again, you know, the judge is trying to just umpire this case and make sure that everybody gets to get in their, you know, their allowable testimony and evidence. I don't know from a judicial standpoint, if I can say anything more than that.
What are your thoughts on this?
Well, as I mentioned earlier,
Yeah.
she was a credible witness, and part of what makes her more credible than the pizza delivery guy is
Yeah.
that she doesn't have an agenda that we can see. She's not talking to the attorney who's suing the city. She doesn't seem to be anti-authority or anti-law enforcement. And so I think, this is an ideal prosecution witness, someone who doesn't seem to have an agenda.
Yeah. Well, in the cross-examination that we have seen in the past from the defense side, there's sort of this ongoing theme that they're trying to discredit some of their testimony. In this case with Malang, the defense was sort of reinforcing the fact that she could not see the full confrontation between police and Manuel Ellis, that part of her view was obstructed from what I imagine is one of the bedrooms in that home. Mo, what do you think their strategy has been here?
I think that kind of confrontation is effective confrontation, is talking about the witness's perceptions. Like, it was too far away, or my vision was obstructed, so potentially what I'm not seeing is not what I'm seeing, or what I'm seeing is something else. But talking about these issues about people's biases towards law enforcement, the problem with that is that the case is being prosecuted by law enforcement.
Yes.
And these witnesses are being called by law enforcement. They're being called by the Washington State Patrol and the State Attorney General's office. So that's where there's like what I call a narrative inconsistency with what they're trying to accomplish.
Certainly. So those were the witnesses that we heard from, but also earlier this week we heard some testimony from Dr. Roger Mitchell. You'll remember that he is a forensic pathology expert who first took the stand last Friday. They continued with his testimony earlier this week on Monday. The defense brought up Dr. Mitchell's activism, something that you brought up, Mo. He calls himself an advocate, and he recently published a book about deaths in police custody. So, Mo, do you think that this made him seem at all biased in the eyes of the jury, and how do you find juries typically react to information like this? This was a few days ago earlier with Dr. Mitchell's testimony.
So I believe that he did a very effective job in establishing cause and manner of death in as objective a way as he could. And on the stuff that he could not testify to with great certainty, he admitted it. He admitted it on cross-examination that this was a very complex case. He admitted it that methamphetamine and his health played a role. However, his conclusion was that it was force that caused Mr. Ellis's death. Then without that force, meaning without the interaction with law enforcement, he would still be here today. And I think it's important to understand, sometimes people get confused, that the manner of death in this case has been called by the medical examiner to be homicide, but homicide is not a criminal word. It just means death at the hands of another.
Sure.
The jury's going to decide whether homicide rises to the level of manslaughter or murder, and he just provided a vehicle for them to make that decision. And he has to testify, because the eyewitnesses can't testify to the mechanism of death. And to then bring out his activism, I don't think that did much to take away from what he was saying.
Yes.
Because
And the other thing
Yes,
is the
Judge.
jury is going to get an expert, what we call an expert witness instruction at the end of the trial. I wish they'd give this at the...
Could you actually explain that, Judge?
Sure, that's what I'm going to do.
Yeah.
There's a separate instruction. The jurors will be told about expert witness testimony. They'll be told, first of all, they don't have to accept any opinions of the experts. It's their job to decide the weight of each of the experts' testimony. And they'll be given a list of things they should consider about the expert's testimony, like, for example, their education, their training, their experience, and some other factors. So they'll get that instruction, unfortunately, at the end of the case. Like I said, I wish they'd given it at the beginning of the case so they could do the evaluation as they're moving through the evidence. But they'll get to decide at the end whether they want to accept the opinion or not.
Well, speaking of expert witnesses, we do want to kind of dive into another aspect of the testimony that I believe we just saw yesterday. This week, the prosecution also called the former forensics manager for the Pierce County Sheriff's Department to take the stand. He responded to the intersection where Manuel Ellis died, and he was also the one to take pictures of the Tacoma police officers after the confrontation. So let's take a look at some video of when the pictures were shown in court. you can see that one of the officers has a couple scrapes on his hand and on his elbow, and that same officer has a broken watch face. That's among some of the pictures that the jury saw. We also saw pictures of the officer's knees, and I believe there was another picture of a watch face that had a crack on it. That's the one right there. Mark, when you see these pictures, what are you thinking? This is pretty much protocol in any given trial, it seems.
Right. One of the things to remember is the prosecution not only has the burden of proof, the prosecution has sort of an unstated burden to present all the evidence, the whole picture, not just what advances their cause. So the prosecution is going to put this all out there, and then later they'll come back to it in closing and argue the meaning.
Well, you were mentioning also earlier that, why would the prosecution be keen on showing the injuries on the officers? Is this something that they're preemptively thinking ahead when it's the defense's turn?
Right. And when I was talking about opening, one of the things you want to do in opening and also in your presentation of the testimony is steal thunder away from the defense. Before they get a chance to make a big point, you present it like it's not that big a deal.
Well, so if you want to think about strategy, and we don't know, but we don't know yet, but are they insinuating that the injuries on the officers were not that intense? I mean, where do you think the defense might take that later on, Mo, if you want to?
If I was a defense lawyer and I was trying this case, I would bring this testimony in, or I would bring this evidence in to show that there was some sort of a confrontation, a physical confrontation that caused injury to the officers and to their watch. Because the officers are going to have to justify the force they used. Someone has to get up there and say, we had to use force. Well, why? Well, look at this. Look at the level of resistance that I was receiving from the person I was trying to arrest. It's demonstrated by the broken watch. It's demonstrated by the cuts. This was not just us hitting somebody or beating somebody who was defenseless. This was an interaction, and there was aspects of this that were not caught on video. And that's the void that this is trying to fill. And to Mark's point, what the prosecutor is doing is stealing that thunder away by putting it out before the jury first, so that the defense doesn't come back and say, where was this evidence? Why didn't they put it in?
Well, they already did, right, as you were saying, Mark,
right.
Yes. Thank you all so much for being here today. There's so much more to talk about. We have limited time, but before we go, what are your final thoughts? Let's start with you first, Judge.
Oh, again, it's early on in the case, so as you know, there's lots to go. They've done a interesting. I like, if I were, I can tell what the prosecutor is doing, that trying to keep the jury interested by not putting all the eyewitness testimony at the beginning. They've kind of interspersed it throughout their case so far. So I think that's probably a conscious tactic that they decided on.
Absolutely, and Mo.
I think that moving forward, I would hope that the defense moves away from involving James Bible or victim blaming, because juries do not like that. And they do not like to see a victim blamed for what's happened. We just don't do that in our society. And focus on the things that they do very effectively: perception of witnesses, and the type of evidence that exists and what is missing, and bringing that story out to the jury to explain to them how this force was justified or not.
Mark, final thoughts.
Well, as I've said before, looking forward to hearing the testimony of the officers, because nothing we've heard thus far really covers how this interaction started. And one of the challenging things about prosecuting a case like this, either as a prosecutor or a plaintiff's attorney, is there's only 4 people who know how this started. One of them is deceased. And so the other 3 are going to have to get up on the stand, and they're going to have to explain what happened. They're going to have to tell their story. And like you said, they'll cite back to physical evidence in the record that supports their version of events. But I think till then, we're just gathering evidence that will be used in closing argument.
And as the judge has been pointing out, we are only getting started. We have a lot more to go in this trial. So thank you all for your insights, as usual. And our thanks, of course, to Parse Everything Out. We'll have much more trial coverage coming up every Friday. And by the way, you can tune in our streaming app, King 5 Plus, available on Roku, Amazon Fire, and Apple TV. Our weekly recap is also available on our YouTube channel. As always, you can keep up to date with our trial coverage on king5.com and our mobile app.